the age-old, centuries-old possibly, definition by an English writer called Sedgwick in his book Sedgwick on Damages, and cited in a 1919 case by the Philippine Supreme Court, defining market value as that reasonable sum which property would bring on a fair sale by a person willing but not obliged to sell to a person willing but not obliged to buy. I don't see what would be the utility of discussing what should be fair market value. We should be discussing the question of whether the defendant committed an impeachable offense when he allegedly erroneously misdeclared certain entries or completely omitted certain entries in his SALN. Let us see what and I come now to the gist of what I really wanted to say. Let us come now to what the Supreme Court has to say. When you fail to properly and completely file your SALN, what are you committing? What crime are you guilty of? In the most recent case, 2011, Presidential Anti-Graft Commission v. Plato, spelled P-L-E-Y-T-O, PAGC versus Plato, promulgated in 2011, the Supreme Court answered, the failure is not dishonesty but only simple negligence. That prosecution panel should be the topic of your next oral manifestation, and particularly your written manifestation or memorandum at the end of this trial. Here is the Supreme Court speaking, and only as of 2011, Plato's SALNs are prepared by a family bookkeeper/accountant. Also, his wife has been running their financial affairs, including property acquisitions, which form part and parcel of her lending business. Thus, he was not directly involved, and he failed to keep track of the real property acquisitions. Here is the important sentence. Consequently, petitioner's SALN was not filed in proper form, containing several inaccurate information. The court had no doubt that the SALN was inaccurate, but it went on to make distinctions among these three terms: gross misconduct, dishonesty, and negligence. It cited the two standard laws, remember, that we began with, the Anti-Graft and Corrupt Practices Act, and then the Code of Conduct and Ethical Standards. This is what the Supreme Court said. For gross misconduct to exist, there must be reliable evidence showing that the acts complained of were corrupt, or inspired by an intention to violate the law, or were in persistent disregard of well-known legal rules. That's what you have to prove, prosecution. The Supreme Court went on, and as for dishonesty, it is committed by intentionally making a false statement in any material fact, or practicing or attempting to practice any deception or fraud in securing his examination, registration, appointment, or promotion. And then finally, negligence. Negligence, said the Supreme Court, is the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. In the case of public officials, there is negligence when there is a breach of duty or failure to perform the obligation, and there is gross negligence when a breach of duty is flagrant and palpable. The Supreme Court goes on. Gross misconduct and dishonesty are serious charges which warrant the removal or dismissal from service of the erring public officer or employee together with the accessory penalties. Hence, a finding that the public official is administratively liable for such charges must be supported by substantial evidence. Prosecution, you have to show at least substantial evidence because this sentence was made in a decision that involved an administrative case, but we are trying an impeachment case. The Supreme Court held that Plato's failure in properly and completely filling out his SALN was not intentional. Supreme Court said, clear from the foregoing legal definitions of gross misconduct and dishonesty is that intention is an important element in both. Missing the essential element of intent to commit a wrong, this court cannot declare petitioner guilty of gross misconduct and dishonesty. An act done in good faith, which constitutes only an error of judgment and for no ulterior motives and or purposes, does not qualify as gross misconduct and is merely simple negligence. And so in the Plato case, the Supreme Court said, thus, at most, petitioner is only guilty of negligence. You have your work cut out for you. Prosecution panel, show that an omission or a misdeclaration was deliberately intended by the defendant. You must show essential element of intent to commit the wrong. Now, in another case, the court found that the defendant was guilty and should be removed from service. The Office of the Ombudsman v. Racho, also a 2011 case. So we have two cases to choose from because the latest case always controls the jurisprudence. In this other case, Ombudsman v. Racho, the court found Racho guilty of dishonesty for non-disclosure of his bank deposits in SALN. Here is a note of caution to the defense. Defense panel, has your client, the defendant, disclosed in his SALN all his bank deposits, peso and dollar deposits? Because if he did not, but he admits that he made those deposits, then under the ruling in Ombudsman, under the ratio decidendi, then your client is guilty. In this particular case, the Supreme Court defined dishonesty. It said, dishonesty begins when an individual intentionally makes a false statement in any material fact or practicing or attempting to practice any deception or fraud. And then finally, just for emphasis, one more case that challenges the position of the defendant. Carabeo v. Court of Appeals in 2009. He was officer in charge of the treasurer of Parañaque City. He accumulated several properties and was able to travel abroad 15 times. He did not disclose this in his SALN. He alleged as a defense that he can simply correct the entries made in his SALN. But the Supreme Court said that while the law indeed allows for corrective measures, the defendant was charged not only with violation of the Anti-Graft Act, but also violation of the Penal Code. He failed to show any requirement that prior notice of the non-completion of the SALN and its correction precede the filing of charges for violation of its provisions. I will now stop myself. I will challenge these two panels. Number one, prosecution, show that there is intent to commit dishonesty on the part of the defendant and you've won your case. On the part of the defense, show that your client has, in good faith, declared in his SALN all his deposits, both peso and dollar deposits, and if he did not, why not? Please take these cases, decided cases that I've cited accordingly. Thank you.